All right, I'm going to share some stuff with you tonight. I'm still working through an article, and I've gotten it about 95% done. It's going to be a little different of a show, so don't tell anybody, don't tag anybody tonight. It's just going to be us. But I'm kind of going back to my roots, going back to scholarship, right, where I'm analyzing papers and that sort of stuff. In this case, I'm analyzing Judge James J. Goodman, Bay County, 14th Judicial Circuit, who made an incredibly faulty ruling in the Mexico Beach recall that took place last month. And I'm not sure if it's being appealed or not. I know Marie Maddox had the case, and it's really quite something. And if you were with me when I did this the other day, I think you're going to get a lot out of tonight. I'm going to try to get right to it and not waste your time. But you're certainly going to understand what I'm talking about. And be fair. Tell me, hey, Bernie, the judge knows the law better than you do. All right. When he cites case law, it applies, because I'm going to show you very specific things, and you can tell me where I'm off base or not. And I really am hoping that this is enlightening. So we're going to get right to it after this.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at. Right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are well. Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777.
All right, I know we're a little late, but you're just here, working through it with me. We'll write it together. All right, here we go. I'm going to try to read through it without... I may edit if I see I've forgotten a word, or if you see a correction I need to make. I'll look at your comments. Some of you say, Bernie, the whole thing is wrong. Okay, I get it. I do. All right, here we go. 3 reasons Judge Goodman got it wrong on Mexico Beach recall. Circuit Judge James J. Goodman upheld the recall petition, citing case law, indicating that it's up to voters rather than the court to decide if the allegations against Mexico Beach Mayor Michelle Miller were factual. Quote, the reasons for recall, whether true or false, do not affect the proceeding. Their truth or sufficiency is for determination by the electors alone. And that comes from case law. You can see it there. But Judge Goodman's ruling ignored the most important aspects of that case as it applies to Mexico Beach. Judge Goodman's decision is wrong for several reasons. 1, he conflated the facts in the petition with the facts of the controversy. 2, he gave judicial notice while ruling he had no authority to consider facts. 3, he ignored the rules of statutory construction. Florida statute provides for the recall of municipal elected officials based on, it's important right there, based on any of the 7 grounds as it relates to their official duties. 1, malfeasance. 2, misfeasance. 3, neglect of duty. 4, drunkenness. 5, incompetence. 6, permanent inability to perform official duties. 7, conviction of a felony involving moral turpitude. The recall committee listed the following grounds for a recall election. Quote, Mayor Michelle Miller should be recalled for malfeasance because on April 30, just a week or 2 after she took office, 2023, she violated the Sunshine Law when she exchanged private electronic communications concerning Springbrook software with members of the city council to discuss matters which would foreseeably come before the board for action. 2, quote, Mayor Michelle Miller should be recalled for misfeasance because contrary to the City of Mexico Beach Ordinance 644, that is the one cited. That's a very important point. This is what I've been working on today. On July 27 of last year, she unilaterally directed a City of Mexico Beach employee to end services with one contractor and to authorize another contractor to access accounting systems, an official act, and without city council approval exceeding her authority as mayor. Judge Goodman used the following definitions. Malfeasance, the commission of some act which is positively unlawful. 2, misfeasance, the performance in an official capacity of a legal act in an improper or illegal manner. Judge Goodman acknowledged that the burden of establishing the propriety of the recall is on those seeking to overturn the regular elective process to base the petition on lawful grounds or face the invalidation of the proceedings. He explained, quote, in accordance with our system of due process, an elected official has the right to challenge the legal sufficiency of a recall petition. Mayor Miller argued that the allegations were insufficient as a matter of law because the allegation of malfeasance, quote, failed to include the necessary facts to demonstrate a violation of the Sunshine Law, end quote. In other words, it lacked any valid basis as required by statute. The misfeasance allegation was void, argued Mayor Miller, because the petition didn't identify the city employee or either of the contractors. And even if it did, Ordinance 644 governs employees rather than elected officials or contractors. Both sides agreed that if either malfeasance or misfeasance was found legally insufficient, then the entire petition for recall would be null and void. This point alone proves that the court has the authority to make such a ruling. The question for the court, says this is the important point here, was not to determine if Mayor Miller should be removed for committing malfeasance or misfeasance, but whether she actually committed either violation through her actions listed in the petition. Let's consider 3 ways in which Judge Goodman got it wrong. 1, conflating facts in the petition with facts of the controversy. It's true that the recall statute does not delegate authority to Judge Goodman to decide if Mayor Miller should be removed for committing malfeasance or misfeasance. That's up to the voters. But since Mayor Miller challenged the allegations in court, it was up to the judge to determine if her actions rose to the level of malfeasance or misfeasance. Was there a valid basis to support the allegations or not? Judge Goodman ruled that the court may not rule on the falsity of the charges or whether the exchange included responsive emails. This is nonsense because there were no responsive emails. A judge's ruling couldn't change that fact. It only needed his acknowledgement. No responsive emails means there's no Sunshine Law violation, which means there's no valid basis for the allegation of malfeasance. It's legally insufficient as a matter of law. This is basic analytical reasoning. Law students must demonstrate their ability to determine what could or must be true based on specific facts and rules. They aren't even accepted into law school without excelling on the law school admission test called LSAT, which has an entire section dedicated to this type of logic. No wonder H.L. Mencken said a judge is a law student who marks his own examination papers. That's a great book, by the way, H.L. Mencken. Judge Goodman concluded that whether Mayor Miller, quote, indeed took such actions or not, and exceeded her authority as mayor, is not for the court to decide, but a question for the voters, end quote. What if the actions described in the petition in no way constituted malfeasance and misfeasance? Then there would be no question for the voters because she would not have exceeded her authority as mayor. Did her actions constitute a Sunshine Law violation or not? That was entirely up to the court to decide. Judge Goodman's refusal to make a determination is akin to Circuit Judge Kelvin C. Wells's recent refusal to determine if the state had lawful custody of attorney Hoot Crawford's Marcy's Law client when he took the 16-year-old girl to his office. If the state never had lawful custody of the teenage victim, then Crawford could not have possibly interfered with child custody. Likewise, If Mayor Miller's actions did not constitute malfeasance and misfeasance, then she could not have possibly committed those violations. I told you that. Oh, I'm not able to make the changes here. Okay. I'll have to remember the edits that I'll need to make. In both cases, the judges ruled that the accusations were sufficient without factual support simply because they were alleged, in spite of overwhelming evidence to the contrary. I'm concerned about judges everywhere and always these days. Judge Goodman instructed voters to make a decision based on grounds that did not exist, in the same way that Judge Wells instructed the jury to render a verdict against Crawford on grounds that did not exist. Facts matter so that voters and juries have correct information to make legitimate decisions. Judges who rubber stamp false accusations pervert justice and erode confidence in the judiciary. Here, Judge Goodman participated in overturning the Mexico Beach mayoral election. The second way, Judge Goodman's erroneous judicial notice. Judge Goodman's ruling contradicts itself. On one hand, he states that the court has no authority to rule on the facts in the petition. But on the other hand, he rules that the allegations of misfeasance are supported by facts. His ruling includes judicial notice of the ordinance cited by the Recall Commission to support the allegation of misfeasance. Judicial notice allows a fact to be introduced if the truth of the fact is generally known or cannot reasonably be questioned. The Recall Committee accused Mayor Miller of exceeding her authority by directing a city employee to get rid of one of the contractors, of one contractor, and using a different one, a violation of Ordinance 644. But that ordinance applies to employees, not elected officials and contractors. Here's where Judge Goodman tried to cure the Recall Committee's failure. He took judicial notice to point out that Ordinance 644 was amended by Ordinance 798, which states that, quote, no elected official shall instruct or direct any city employee in the performance of their daily job tasks, but shall act through the city administrator, end quote. Judge Goodman continued making the following assertions. Quote, indeed, the applicability of a city ordinance, this is Judge Goodman's analysis now. He put this in the ruling. These are his words. This is not case law. This is him making an argument. The applicability of a city ordinance concerning a policy for employees' conduct to the mayor depends on the specific language of the ordinance, as well as the powers and duties of the mayor that are outlined in the city charter. Moreover, case law throughout the state confirms that the powers of a mayor could be limited or subjected to some reasonable rules and regulations prescribed by the city council. He also said, indeed, a mayor as the chief executive officer of the city, and this is case law, is generally expected to ensure compliance not only with the city, with the charter, but also with the ordinances of the city. And then he cites LaMelo. Even if Judge Goodman had begun a sentence with indubitably, it's still Tweedledee logic, is what Tweedledee said in Alice in Wonderland. If it was so, it might be, and it were so, it would be. But as it isn't, it ain't. That's logic. I mean, that's Tweedledee logic. Incredibly, the judge cites LaMelo. Case law in which the mayor for the city of Sunrise was indicted and charged with corruption by threats against a public servant. That city's charter directed the mayor to enforce ordinances and rules. This is very different from the charter of Mexico Beach, which directs the council to enforce the duties and responsibilities imposed on the city by law. In support of the recall committee's allegation of misfeasance, Judge Goodman cited case law comparing the actions of a city councilwoman in a council manager form of government, Smyrna Beach, to Mayor Miller's actions in a mayor council form of government in Mexico Beach. This is like comparing apples to semi-trucks. His erroneous judicial notice opened several cans of worms and led him down yet another rabbit hole. And that is violating the rules of statutory construction. A legal doctrine known as the rules of statutory construction mandates that let's see, here's what I need to edit. All right, I'll say it since it's not written properly. A legal doctrine known as the rules of statutory construction prevent a creation from being more powerful than its creator. That's why city ordinances can't supersede county ordinances, and why county ordinances don't supersede state statute. Likewise, a city ordinance does not supersede the city charter, and any ordinance that is in conflict with the charter is null and void. In order to be legitimate, they must be harmonious as a whole. Mexico Beach's 2015's legal opinion drove home the point. Quote, a city charter functions as a constitution from which a city council cannot materially deviate except by the same means which it was adopted. In other words, a municipal charter is the constitution of a city and effectively limits the legislative power of a city in the same manner the state constitution limits the power of the legislature. Mexico Beach's city charter included language with plain meaning, and it was clear. Quote, the mayor shall be the chief elected administrative and fiscal official of the city, end quote. The city's 2015 legal opinion states, quote, the mayor has powers beyond those of another individual council member, though those powers are not specified clearly, end quote. It emphasized that the ordinances that formally established the city administrator position, quote, should not be interpreted to have established a council manager form of government by removing the mayor's powers and granting them to the city administrator, end quote. Not only did Mayor Miller have the city charter and the law on her side, she had the city's longstanding customary role of a strong mayor form of government as well. During a city council meeting in 2022, then Mayor Al Cathy said that the charter delegates the mayor as the CEO and CFO of the city. And then all 5 members of the council voted to give themselves a raise, with the mayor making a higher salary because of the added responsibilities. Not to belabor the point, but earlier this year, the Legislative Auditing Committee declared that Mexico Beach was a strong mayor form of government. State Representative Griff Griffiths nodded his head in agreement. Judge Goodman knows the rules of statutory construction. He's aware of all this, but in his ruling, he noted neither party asked the court to consider the city charter. Well, neither party asked the court to consider the amendment to Ordinance 644 either, but he did so anyway with his judicial notice. He certainly could have done the same thing regarding the supreme governing document of the city. Even so, it's not true. Mayor Miller's central argument was that the charter delegated the mayor with additional duties and responsibilities as the chief elected administrative and fiscal official of the city, or, as former Mayor Al Cathy called it, the CEO and the CFO. And that is just about the entirety of the article when it's finished. And by the way, if you want to make sure to get it, I'm going to have it's going to be complete with links and all of that. And if you want to be sure to get that and never miss a show or anything, and get my weekly email of all the shows and all the Facebook posts, here's how to get it. It takes like 20 seconds and it's free. If you go to bernie.substack.com, that's what it'll look like when you get there. bernie.substack.com. All you do is put your email in there, and every Friday you'll get all of the shows and all of the posts. You don't even need Facebook to get them. And it's free. Now, there is a way to get a paid subscription if you want to, but you don't have to. That's just to say, Bernie, keep it up. I support you. Here's a paid subscription, but you don't need to. Bernie.substack.com. I'm hoping to have this particular article out tomorrow as an extra email this week, because the Friday regular one will be coming out as well. All right. I wanted you to see that, and I hope that makes sense. I'm going to be looking at your comments if you have any questions, or if the article sparked an additional point you think I should add. I'd love to see it.
Strong, effective leadership. 3 words that could mean the difference between prison and your freedom. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
And thank you to those of you who throw a tip in the tip jar through Patreon and our patrons at patreon.com/Bernie Thompson. Crowdfunding. I mean, this wouldn't exist without it. So thank you. Thank you. As little as $5 a month, patreon.com/Bernie Thompson. It's easy. It's anonymous, and you can quit at any time. And as always, I want to thank another sponsor, the Unknown Patriot, for your support. And as I said, it's quick and I'm out of here, but I've been working on this. Writing is, it's what I'm trained in and educated in, and all that stuff. I just don't do it enough, and I need to get back to it a little bit more, I think. And it's different than doing a show, because I was a writer before I was a radio host in 2007. And they're very different. To do this, I believe that you just come on and connect and just talk. You don't have to be particularly profound. You just come on and connect. But with writing, I am much more precise, and it's harder for me anyway, but it clarifies a lot. I used to teach college writing. I taught persuasive writing at Penn State, at here at Gulf Coast College in 2007, and at Weber State in Utah. And one of the things that I would tell the students is, if you want to learn how to write, write. And if you want to learn how to write well, read. I don't even know where that came from, whose quote that was. I could never find it, but it was sure true. The more you read, somehow the better writer you become. And when you write, you understand issues better. And I wanted to get to really the crux of where Judge James J. Goodman was wrong, because I knew he was very wrong, but I wanted to be able to put it in a way that perhaps even helps the appeal, if there is going to be an appeal. I know a notice of intent to appeal, a notice of appeal was filed, and it's important that it is done because this was so egregious. Judge Goodman is smarter than I am, and he certainly knows more about the law. I mean, I always joke about being Bernie the attorney. I'm not. That's how I know there's something really wrong here. So I'm doing my best to be able to lay it out and clarify it for all of us. And this was just one way to sort of help out that process. So thanks for being with me, and I'll see you again soon.